Yo, what's up everyone? Mike Hill, the Wholesaling Titan here. And what I want to talk about in today's video is doing assignment deals. So I want to start with a very brief review of what an assignment is. Then I want to show you when it's appropriate to do an assignment versus say a double closing. As many of you know, one of the disadvantages to using an assignment contract is that your end buyer gets to see your fee right off the bat, so they know exactly how much you're making. I'm going to show you one option where you can actually do an assignment and not disclose that to the end buyer. Next thing I want to do is make the case that not all assignment contracts are created equally. I'm going to show you the contract that I was using when I first got started. It's actually probably the most common one. If you go to Google and just search assignment contract, it's probably the first one that'll pop up. It's probably the one that a lot of you are using at home, and I want to show you why it's probably not the best option. Then I want to show you the one that I'm currently using in my business, kind of walk you through it, explain to you why I think it's a much better option, show you how to fill it out, and then give you an option to download it so you can use it in your own business. So that said, I want to start with a quick review of what is an assignment deal. Like, how does it work, right? So the first thing you got to understand, because I get questions about this still, is that there's only one purchase agreement in this type of transaction. So the purchase agreement you have between you and the seller, and then you get a great deal and you go to an end buyer and you say, listen, I've got this great deal in this house. I will assign my rights to this contract to you for a fee, right? And so that's your assignment fee. So just to give you an example, let's say you have a house that's worth $100,000. You get it under contract for $50,000. You go to the end buyer and you say, hey, I've got this great house. I got the contract for $50,000. I'll sell it to you for $10,000. So you're just flipping the paper. And then they say yes, so they're all in for 60. You take the 10 as your fee. They close on that first contract for $50,000. So there's only one purchase agreement. That's different from, say, a double closing, which you guys have probably heard me talk about, or maybe you're familiar with, where there's an A to B contract and a B to C contract. There is no assignment contract with a double closing. There are two separate purchase agreements. So I have one with the seller. I will purchase and actually own the property, even if it's only for 5 minutes. That's typically done with transactional funding. And then I will have a separate purchase agreement with my end buyer where I'm now the seller and they're buying the property that I now own from me in a separate transaction. So when should you do an assignment? Well, first of all, you have to make sure that your contract is assignable. So back in the day, you would write under the buyer name, you'd write your name. So let's say Mike Hill and or assigns. I do not recommend doing that anymore. I think it's a huge red flag. Typically, the way you want to do it is just on your contract, using the proper contract. And again, I do recommend using the Board of Realtors state approved contracts. There should be a little checkbox that will indicate if the contract is assignable or not. Now, one thing just to keep in mind is that anytime there is an addendum, it will always override what's in your original contract. So as an example, if I am making an offer on an REO, a bank-owned property, and I check the box assignable and I send that to the listing agent, they will send it back with an addendum. Within the addendum, it will say this contract is not assignable. That will supersede what I've already written in there. So first off, you got to make sure your contract's assignable. Next, I have a very general rule which says if you're making $10,000 or more, you want to do a double closing. And that's because the fee is not disclosed. Now, in a perfect world, in an ideal world, the buyer has agreed to the deal. They say, hey, I feel like I'm getting a good deal. I don't care how much you make. Now, I've had buyers say that to me, and I've learned it the hard way. It's happened to me, it's happened to my students, and it's happened to all other wholesalers I know. The buyer says, hey, I don't care how much you make. I like this deal. Then they see how much you're making, and then all of a sudden it's a big problem, and they want to negotiate your fee down. It happens. Say they're buying a property for $100,000, you're making $20,000. You're saying, hey, you're not doing any of the work, you're not taking any risk, and you're taking a fifth. No way. And if you don't have a backup buyer, and maybe you're running out of inspection days or something like that, then a lot of times you don't have that negotiating power, and then you have to lower your fee. Now again, that number $10,000, again, that's just a general rule. It really does vary. You know, if you're in Alabama and you're flipping $5,000 houses, it's going to be very different if you're, like one of my students in California is working on a deal for $600,000. So again, the fee is going to be relative to the property. Also, it depends on the buyer. Do you have rapport with them? Do you have backup buyers? Stuff like that. But in general, If you're making a significant amount of money, you don't want the buyer to know, then you typically will do the double close. But I'm going to show you a little trick in just a minute where you cannot disclose the amount that you're making on your, even when doing an assignment. But we'll get to that in just a second. Also, if you're doing a double closing, and some of you might be saying, well, with double closing, there are more fees associated. And yes, that can be true because they're two separate transactions. So you're going to pay closing costs on the A to B, and then you're going to pay a percentage of your transactional funding. So in a lot of cases, that might work out to something like $4,000 or something like that. Now, if you're thinking, I don't have that money, don't worry, because you don't have to come up with that up front. That comes out of your profit on the back end. So let's say, just look at it this way. Look, in the example from before, if you're going to make $20,000, a buyer sees it and says, no way, I'll pay you 10, you just lost $10,000. In an assignment situation. If it's a double close and you're going to make $20,000 and they don't know about it, it's worth paying the 4 and then you just make the 16, and it just makes more sense that way. So next, that's kind of the general rules there. I want to look at these contracts, right? So the first one that I've got pulled up here is the most basic. Now this is the one that I got when I first got into wholesaling. And all it says basically is that, hey, I've got this contract. I'm assigning all my rights to you. So basically now you're getting the contract. So pretty simple stuff here. You pop the date in here between assigner, that's going to be you. The assignee is going to be your end buyer. So you just put the name or the name of the business right there. And then it just says here, the assigner is assigning all interest to the contract. And then you put the terms in this little blank area here. So it would say, I'm assigning the contract to John Smith for $10,000. And then all it's saying here, without reading through all this, is, like I said, basically the end buyer's taking over the contract. Now, what I don't like about this contract is it can be very vague, and there's some things that are ambiguous. So, for example, let's say you have a contract and your contract has a 7-day inspection period on it. It's pretty typical. And then on day 2, you take it to your end buyer and you say, hey, I'm assigning this contract to you. Well, now they technically own that contract. So now they have 5 days remaining in their inspection period. Now, this hasn't happened to me, but hypothetically, that buyer could legally make the case that, okay, they still have those 5 days of inspection period, and now they want to cancel that contract, and then they'll go ahead and sign a new contract with the seller. They can go right around you, cancel your contract, and start a new one. Is it kind of shady? Of course. Are there sharks in the real estate business? Of course. So again, this is one of the reasons I don't like this contract. Some things are just too vague, too ambiguous, and I'd like a little bit more protection for myself. So if you see this one, I'm going to advise that you stay away. And let's look at the next one, another common one, better, still not best. But I'll show you some of the differences here. So first off, again, you put the subject property in description. Assigner is you. Assignee is your end buyer. It says you're in the purchase and sales agreement. Now here, you'll see here the assignee will pay assigner a non-refundable assignment fee of. Right here is where you just put in the number. So it's a little bit easier to just pop that thing in there. And then it does specify that it's non-refundable. One thing I always tell my students is, no matter what you talk about, no matter what you say, no matter what's agreed on verbally, everything has to be in writing, and you want it as specific as possible. So it's very good here that this does say that this is non-refundable. The next thing, that hypothetical I talked about earlier with the inspection period, this second clause here just kills that right off the bat. The inspection period expires upon execution of this assignment. All right. Third, then the assignee just acknowledges that they have legible copies of the original contract. I mean, that's good, because then the end buyer can't say, hey, I didn't know XYZ, or this wasn't disclosed to me. Again, it's a little sketch, because then they can see things like, if they insist on seeing the contract before signing, they can see things like, when does your inspection period end? And in some cases, they might choose to try and wait it out and maybe go around you again. So that's just something else that a little iffy on this contract, right? And then this here also specifies that this assignment contract is not assignable, something that the first one does not say, and something that's important, because let's say you have someone, this basically reduces the chance that the end buyer doesn't close, because if they're trying to flip it again, there's a good chance you just increase the likelihood that they might not close on the deal, and then you get screwed, and then the seller gets screwed, and just everyone kind of loses. So again, this is a little bit better. Again, it's a very simple one-page document, but not best. So next, we're going to jump into and spend the bulk of our time here in this third option. So again, this is the assignment that I am currently using. And very quickly, up here is just everything very standard, again, between the buyer and seller. Now, here's what's pretty cool here. The assignment fees. And the way, this is just a matter of the verbiage that's used here. It's essentially saying the same thing. But if you notice, it says the assigner is going to assign this to, and then you put your buyer name in here, for a total purchase price of. So you put the total purchase price. So let's say, in our example from earlier today, you had the contract for $50,000 and the buyer, you told them, hey, I got it for 50, I'll sell it to you for 10. This you would just fill out for a total purchase price of $60,000. So at the time of the signing of this very, very binding, and you'll see why the language is a little bit stronger in this contract, the buyer is agreeing to pay $60,000 total. They don't know if you have the contract for 30 and you're making 30, or if you have 50 and you're making 10. Now, yes, they will see that right before the closing. They'll see it on the HUD statement, so they will know your fee, but typically they won't know that right up until the closing. So that's how you can, it's not total non-disclosure of your fee, but you can really delay it to the very end, and that really reduces how much the buyer is really going to balk or kind of fight back. Also, you'll see that this contract's a lot tighter in terms of binding. So even if they do see the fee a little bit later, they're already going to be locked into this contract. So right off the bat, just the way that this is phrased, I like that a lot better, okay? So next, you're going to put in right here, you're going to close on the property before and then put the closing date. Next, you have here a signer at their sole discretion. So this is you at your sole discretion. You have the option to terminate if the buyer doesn't provide proof of funds to your satisfaction. So this contract is specifying that you do have the option to verify their proof of funds. If you know it's a good buyer or something like that, you don't have to, you don't need to require it, but it does give you the option and say that you can terminate. So again, this contract is geared towards protecting your interest and make sure that everything's in your best interest, right? Next, the agreement's not binding until a signer has received your earnest money deposit, and then you put that number in there. Typically, it's going to be $10,000, and then you put whoever's holding your earnest money right here. So this is my preferred title company, Independence Title. If you guys are closing in the state of Florida, they do close anywhere here. I got a million amazing good things to say about these guys. Great testimonials, great company. Always want to work with a reputable, not just a reputable title company, but a title company who's very investor friendly. And I could do a whole video about that, and I might do that in the future. But these are good guys. They do closings anywhere in the state. All right, so next we have, again, that it says that their money is not refundable. Now, again, some of the things as we run through this will be a little bit repetitive, and you'll see things that should be kind of understood or assumed, or it seems like it's repeating, but this is only for your protection. You'll see that banks do it. Any of the standard addendums that you'll see in REOs or Fannie Mae, they will repeat things just so it's crystal clear. You don't want any subjectivity, anything that can be argued, anything open to interpretation. So you want everything just ironclad, really, really tight. So that's why some of this, if it seems a little bit repetitive, it's only for your protection. So again, we're specifying here that this earnest money is not refundable. Sorry, there's a lot of verbiage here. I'm getting a little bit lost. So let's just go through this here. Let's just go back just a little bit. If the buyer does not close due to no fault of the seller and or signer and clear and marketable titles in place, all the deposits will be considered liquidated damages and non-refundable to the buyer/assignee and will be released to the assigner immediately. Now, here's the important part. The buyer-assignee agrees that no additional release of deposit or cancellation of contract will be required. By signing this document, the buyer agrees that if they default for any reason, these provisions will be followed and the deposit will be considered liquidated damages and immediately released to the signer upon request. So here's why this is important. Typically, the earnest money, even though it's held in an escrow account and you guys have your agreement about performance, a lot of title companies, and again, this is why you have to work with a good investor-friendly title company, they still require written consent to release funds. So by putting this in the contract, it basically says that this is the written consent. So if there's any type of anything could go wrong in the deal, and the buyer could say, hey, I'm not signing that release. And then you can have to litigate and go to court and all this different stuff to get the money that's entitled to you, because the title company can't release it, otherwise they could be in trouble. So again, that just kind of knocks that out, and so it's just one less thing that you have to worry about. Basically, if the buyer doesn't close, that money is yours. So you know that once it's in the account, unless something's wrong with the title, you're going to get paid whether the buyer closes or not. And then it actually goes into a little bit more detail. Earnest money is not refundable for any other reason. The assigner may retain all of the earnest money. And then another thing here is specified. In the event the agreement is placed in the hands of an attorney for enforcement, the prevailing party shall be entitled to recover court costs and attorney fees from the losing party. Just something, again, to protect you a little bit more that's not in the other assignment contracts that we looked at. Next is similar to the other one. It does specify that this assignment contract cannot be flipped by another buyer. Not only does it say that, but it says the assignee or buyer cannot advertise or promote the property prior to closing and will be deemed in default if they found to do so. Now again, this is just giving you the option. If it turns out they do advertising, I have buyers who they basically buy from me and then they kind of advertise it. It's weird. They advertise it as they're doing the repair. So if I sell it to them for $150, they'll immediately start advertising at $160. If they have someone that'll buy it from them, they'll do it. If not, they'll start the rehab, and then maybe they'll put it on the market for $190 halfway through the rehab if they're doing basically just paint. And then if no one buys it, then they'll do the full rehab and put it on the market for $200. So it's not necessarily if they advertise it, you have to call them on it and have them default on the contract, but you have the option in case you want to. Okay, next thing here, it says the buyer assignee waives right to record a notice of interest in the public record. So what this is doing is basically if you sign this agreement, it's executed, and then for some reason, let's say the buyer doesn't close, and maybe you get their earnest money, and then you go to sell it to somebody else. If they go and file a notice in the court, in the public record saying, look, I have rights to this property, I have equitable interest, I have this contract, then essentially that could cloud the title when you go to sell it to someone else, and then you have to pay them some money to release the lien or something like that. So this is basically saying they cannot do that. So if they don't close or they mess up, they can't tie you up into the in this agreement so that you can't sell it to someone else. So again, it's just another important protection. This one's not very common. It's not likely to pop up, but it could. And so you want to kind of protect yourself against all possible scenarios, which is why it's so important to just have all these different provisions in this contract. Next, again, just in your interest, the assigner reserves the right to continue to offer the property for sale until this offer has been formally accepted in writing. So that's pretty cool. Next, the property is being sold in as-is condition. That's important. Another thing, it is about just repeating certain clauses. Like, yeah, you might sign an as-is contract, but it's worth saying, hey, I've never been there. I don't know anything. I just have the contract, just to reduce any type of liability. You just want to make these things crystal clear. And again, it's just worth repeating sometimes. So again, it's basically saying here that you are held harmless. By the way, I usually have a disclaimer. I'm not an attorney or giving any type of legal advice. This is always my interpretation. Nothing is legal advice here. If you're not understanding things, I always advise that you consult an attorney. It's my interpretation and showing you how I do business and why I personally do it this way. All right, this next part is very, very important here. So what this is saying is that, where are we? This is talking about permits. Assignee agrees that property is being purchased with all open expired permits and shall not be required to be closed by assigner or seller prior to nor after the closing date. A signer or a seller shall not be liable for any open expired permits, either prior to or post closing of the property. I've learned the hard way that permits can be a huge pain in the ass and it can really screw your deal. Now, one thing with permits is not all buyers, and sometimes even buyers who are somewhat experienced, who have done even a couple of properties, they might not fully understand. And also, it depends on the type of purchase contract you're using. If you use one of these 3-page like wholesale contracts that I don't recommend you use as your purchase agreement, they might not talk about permits at all. If you use a contract that's drafted by an attorney, it might not talk about permits. Depending on your state, the legality and who's responsible for permits may differ. In Florida, I believe the standard FAR bar contract puts the responsibility of taking care of those permits on the seller. Now, I don't use those contracts. I use the as-is contract. In the as-is contract, the responsibility of, yes, the seller is supposed to disclose it, but the responsibility falls on the buyer. Not all buyers are knowledgeable about that. Also, there are times where these things can pop up if you're depending on your title company. They may not find permits. They might not do the search. So that's where you got to, again, have a reputable title company. Some people think that because it says that you're going to get clean title, clear and marketable title, that covers permits. That does not. Sometimes the seller will close on the property and they'll find out about a permit and then they'll say, I wasn't told. And then they might try to come after you or try to sue you, or it might just damage your reputation. I remember I had a situation a long time ago where we were doing the deal and the seller was like, hey, you said the permits came up. Hey, you said you were purchasing as is. And then the buyer's like, we never talked about any permits. I'm not taking it with any open permits. And then I'm there in the middle like, oh shit, I don't know what to do. I thought the buyer was buying it as is. And that can even damage your reputation, because then as a wholesaler, it looks like I'm trying to pull a fast one on the buyer. And then everyone's kind of, in this weird place. And I think this is like years ago, but I believe I ended up kind of taking a hit on my fee just to get the deal done, or I might have split it with the buyer or something like that. But again, this is just making it so there's no subjectivity. So it's just crystal clear. It's right there. The buyer wants to say, hey, I didn't know about these permits. You just point to the contract. Hey, this is what we agreed on. We both agreed on it. It's in writing. Our signatures are on both of this. There's really nothing that you can say. So that's just another protection that you have in there. And sometimes, people try to stall with these different things. And so it just reduces a lot of liability, and it's in your best interest, right? So next, we talked about this before. Assignee shall have 0 business days after the executed assignment date to do inspections. So that goes back to that hypothetical we talked about in the first case. The inspection period here is done, right? Let's see what else. I know we get some other cool stuff in here. It does talk about HOAs and stuff like that. It also says somewhere in here, I know we talk about, it is saying the assigner holds equitable interest in the property. So that's basically just telling them, again, it's not even saying that, hey, they've seen the purchase agreement, but it is telling them that, hey, it's a contingency. It's understood if you're signing this that I, or the wholesaler, you, has equitable interest in the property. It's also making it very clear that you're not doing anything illegal. You're not acting as a broker. You're not advertising a property the way a real estate agent would if you're not a licensed person. You're saying, I have equitable interest because I have the purchase agreement. So that's another thing just to kind of protect you. Talks about HOA stuff, which again isn't covered in the other assignment contracts. And then again, the only contingency to this contract is clear and marketable title. Next is very cool. At the assigner's discretion, the assignee agrees to extend the closing date for up to 90 days if for any reason the closing agent needs more time to close the transaction. So I can tell you there have been so many things that have popped up. I couldn't even tell you all of them for different reasons. You don't want your buyer to have like a way out. If you just have a specific closing date and then maybe they had a backup offer on some other property, and then they say, hey, you're not closing by the date, so I'm going to cancel, and then they get to walk away and get their earnest money, refunded because you didn't perform. So now you're saying, hey, we got up to 90 days to take care of anything that needs to be taken care of. So again, they're locked in. You can see how much more binding this contract is, how much better it is. So that's in your benefit if you need time. and then we get the magic. However, once the closing agent is ready and there's clear and marketable title, the assignee agrees to step in and close within 48 hours of being notified. So sometimes I've had buyers, I don't know if they were trying to get their funding together or if they're just slow or dragging their feet, especially if you're first getting started and you're just waiting for that first or second deal and you need that money like you need water, and they're just taking their sweet ass time, and you're just like, damn, man, how long am I going to wait? And you're worried. This is something that's saying, hey, 48 hours, you close on this, or, not to be a jerk, but we both agreed to this. I got that earnest money deposit, so let's close this deal. Also, assignee agrees to send all funds required to close via wire transfer to the closing agent at least 12 hours prior to the closing date. Again, I encourage you to work with your buyers if there are legitimate reasons. These are not things that you have to enforce. You don't have to be a jerk and be like, well, it's been 49 hours, so I'm taking that earnest money deposit. But it's more just for your protection. If for some reason the buyer's really dragging or they're not returning your calls, you can leave this message, hey, pursuant to the contract, we agreed on this, so I really, really need to hear from you. Otherwise, we're going to have to just, do what we got to do. But, I do, don't look at people. You're not trying to do one deal with the buyer. You're trying to do as many as you can. So you really want it to be a pleasurable experience for all parties involved, but you got to have your boundaries, your standards, and just, again, you guys are both agreeing on this from the jump, so nothing is a surprise. There's no reason for a buyer to get upset with you or go tell anyone you tried something shady or you pressured them or anything like that. All right, next, again, we got all closing costs to be paid by the buyer. What else is in here? This is another good one. And again, it's good that it's all here in writing. It's no subjectivity, no what if kind of situation. So, and this is something that happens to me quite often. You guys hear me talk about this. A signer may at any time before closing renegotiate the purchase price in the contract with the seller. A signer, that's you, is entitled to the entire difference between the contract purchase price and this assignment. The difference, if any, will be paid as an additional assignment fee at closing to the assigner. A signer's negotiation of the purchase price will not affect the total due at closing from the assignee. That's important. So let's say, in our example from before, the contract is $50,000. You tell the end buyer, hey, I got this property for you for $60,000. So now they sign it. They're entitled to the contract, right? So without this clause, if you went back to the seller and you said, hey, there's something wrong with the roof, and we need this for $40,000. And the seller says, okay. They give you that $10,000 price reduction. Without that clause, the end buyer can make the argument they might be entitled to that money, to that $10,000. And so you'd still be getting your regular assignment fee with, say, that first contract that we talked about. So you wouldn't have that option to renegotiate, or you would be doing it just on the behalf of your end buyer. With this makes sure that you can, make a little bit of extra profit for yourself when it makes sense. So if you went back and got that $10,000 price reduction, that will go straight into your pocket. Both parties agreed the closing agent releases the escrow deposit, and that the assignee and assigner have no claim against the escrow agent. So that protects your title company, so they're comfortable releasing funds to you, knowing that nobody could, come after them, right? So just to review again, the check marks here, it's pretty easy, pretty obvious. That's where your buyer is going to sign. They're the assignee, so they're going to initial here. You're the assignor, you initial here. The buyer initials here. Same thing on this page. Bop, bop. And that's pretty much it. And then I always like to attach the wire instructions to the bottom of this letter here. So it's just everything's just much easier, smoother for the buyer. Now there's no what ifs, everything's very much crystal clear, and nobody can say, well, you said or you did, or everything's right there. So this is the assignment contract that I use in my business now. I highly, highly recommend that you adopt it and do the same. I will put a link below this video or somewhere on this page where you can, this will be available for download on my website. And of course, I will take off the specific things like my title company in case you are using a different title company or somewhere else, so you can modify it to your own needs. So I hope that is helpful. If you guys have any questions, please do put them in the comment section. Please do like, comment, subscribe. Helps the channel out a great deal as always. Thank you for watching. I hope you enjoyed, and I hope this helps you in your wholesaling business. If it does, please, go ahead and leave me a note as well. Comments are welcome as much as questions. So with that said, thank you so much for watching, for tuning in, and I will see you guys on the next video. Peace.